Everybody, I'd like to call us. Welcome to meeting number 29 of the House of Commons Standing Committee on Justice and Human Rights. Pursuant to the order of reference of February 2nd, 2006, the committee is meeting to continue its clause-by-clause study of Bill C-16, an act to amend certain acts in relation to criminal and correctional matters, child protection, gender-based violence delays, and other measures. Today's meeting is taking place in a hybrid format. Pursuant to the standing orders, members are attending in person in the room and remote. Is anybody on Zoom? No. I don't think so, no. Okay. I'd like to make a few comments for the benefit of witnesses and members. Please wait till I recognize you by name before speaking. For those participating by video conference, and I don't think there are any, click on the microphone icon to activate your mic. Please mute yourself when you're not speaking. Reminder that all comments should be addressed through the chair. For members in the room, if you wish to speak, please raise your hand. For members on Zoom, please use the raise hand function. The clerk and I will manage the speaking order as best we can, and we appreciate your patience and understanding in this regard. I'd like to welcome our witnesses back. They're here to answer technical questions. I will say that again. They are here to answer technical questions that you may have. So thank you very much, Mr. Taylor and Ms. Burt. You really need no introduction again at this meeting, having spent so much time with us. So when we adjourned, we were debating the sub-amendment to CPC 23. So we will continue there and start a new speaking list. And Mr. Brock is first on the list, followed by Mr. Lawton. Mr. Brock, you have the floor.
Thank you, Chair. I'd like to start off by indicating, just recapping how things progressed last Monday. I believe every member of this committee will recognize the efforts made by Conservatives to essentially deem movement of literally probably the last two dozen and a half government amendments without the necessity of any explanation, because I truly felt we were on a path to complete Bill C-16, clause by clause. I'm not going to get into the circumstances that came up at the very last minute with respect to the deferral of two amendments, two Conservative amendments. That's water under the bridge. But for the record, I want to telegraph that it was the Conservatives' attention all along to see passage of Bill C-16 out of the Justice Committee. And I believe, strongly believe, that there is a pathway to that today. But to get to that pathway, I wish to put on notice, I'm seeking unanimous consent for the following motion. And this will be provided in writing shortly. That notwithstanding any motion previously adopted by this committee, following the completion of clause-by-clause consideration of Bill C-16, the Standing Committee on Justice and Human Rights prioritize its work as follows. Number one, at the May 25th, 2026 meeting, the Minister of Justice and Attorney General appear for no less than 2 hours regarding his mandate and priorities as per the motion unanimously agreed to on September the 23rd, 2025, provided that the time allocated for his answers excuse me, the time allocated for his answers during this meeting not be greater than the length of time taken for the question. Number two, the committee consider Bill C-321, an act to amend the Youth Criminal Justice Act, on May 27, 2026, provided that the sponsor of the bill be invited to testify along with any other witnesses deemed relevant by committee members and that following the testimony, the committee immediately proceed to clause-by-clause consideration of the bill, and the chair only be authorized to adjourn the meeting after clause-by-clause consideration of the bill is completed. Number 3, the committee consider Bill C-325, an act to amend the criminal code, increasing parole ineligibility, on June 1st, 2026, provided that the sponsor of the bill be invited to testify, along with any other witnesses deemed relevant by committee members, and that following the testimony, the committee immediately proceed to clause-by-clause consideration of the bill, and the chair only be authorized to adjourn the meeting after clause-by-clause consideration of the bill is completed. Number 4, the committee proceed with drafting a report with respect to its study on the bail system, sentencing, and the handling of repeat violent offenders, with an emphasis on measures it recommends beyond Bills C-14 and C-16, provided that the testimony received during the studies on those bills be used as evidence for the purposes of preparing the report, and that the report be tabled in the House no less than 5 sitting days after it is adopted by the committee. Number 5, prior to the summer adjournment, the committee dedicate 2 meetings for its study of the appointment of judges to courts under federal jurisdiction, as per the unanimous motion agreed to by the committee on September 23rd, 2025. Number 6, the committee schedule a meeting for the purposes of studying the main estimates 2026, 2027 with the Minister of Justice and the Attorney General for no less than 1 hour, and an additional hour with his officials, provided that the meeting take place prior to the completion of the relevant supply cycle, and that this ministerial appearance not be combined with any other appearance listed in this motion, and that time provided for his answers during this meeting not be greater than the length of time taken for the question. I propose, Mr. Chair, that we suspend briefly so that this can be submitted to all committee members in both official languages.
Ms. Lattanzio?
I think I understood, and maybe a point of clarification in terms of my colleague is seeking unanimous consent to be able to present this motion. Am I correct?
Correct.
Okay. So he read everything. So are we?
I was
Yeah.
waiting to see if Ms. Lattanzio was finished talking, yes.
Okay.
Okay, yeah. Do we have unanimous consent?
No.
No, okay. Thank you. Sorry, which takes us back to the sub-amendment of to CPC 23. And Mr. Brock, I take it you're finished speaking?
I am for now.
Okay, thank you. Which takes us to Mr. Lawton.
Thank you very much, Mr. Chair. So we're debating here the sub-amendment that was put forth on Monday by Mr. Mantle. Just for confirmation, that is to add to an amendment, or rather, to add to an amendment from Mr. Baber.
Substitute.
Pardon me?
Substitute.
Substitute, yes. An amendment from Mr. Baber on Clause 63. Now, this is the clause dealing with the so-called safety valve, which the Liberals have opted to put in Bill C-16 to tremendously weaken the force and effect of mandatory minimum penalties. And what Mr. Baber's amendment does is it says in determining whether the specified term of imprisonment would amount to cruel and unusual punishment for the offender, the court shall consider the particular circumstances of the offender and not consider any reasonably foreseeable circumstances or hypothetical scenarios. And what Mr. Mantle's sub-amendment does is it replaces all the words in there that we just read in determining the constitutionality of mandatory minimum penalties, the court shall not consider reasonable hypotheticals. So that would become the text of sub 1.1. Now, I'm with all due respect to Mr. Baber, I'm inclined to favor Mr. Mantle's sub-amendment slightly more, but I think it's important to situate this in the context of the actual clause we're discussing here. And that is clause 63 and sub 1 of 718.4, which says, when opposing a sentence for an offense that has a minimum punishment of a specified term of imprisonment, the court shall impose a shorter term of imprisonment than the specified term if, in the circumstances, the minimum punishment would amount to cruel and unusual punishment for that offender. And I'm going to turn to the officials in just a moment on this, but as far as where I hope this came from, we had in the fall the Senville decision from the Supreme Court of Canada, which was rooted in a really horrendous decision by the Supreme Court. But the truly atrocious part was actually the original trial judges in the Senville, trial judge in the Senville and Nod cases, who found that a mandatory minimum penalty of 1 year was itself cruel and unusual punishments for men who were possessing hundreds each of videos and images of absolutely horrific child sexual abuse and exploitation material. And as has come up in discussions we've had with witnesses on this, and as has come up even as we've debated some of the clauses and amendments on Bill C-16, we have to look at mandatory minimum penalties as a safeguard against this sort of really insane leniency that some judges are inclined to give to really brutal offenders. Now, if I had my way, the 1 year mandatory minimum would be back in. It would be defended with the notwithstanding clause, so we don't have activist judges shouting down what parliamentarians, representative and accountable to the people, have said. And we would also ensure, if in an ideal world, that it was more than 1 year, because for the types of crime we're talking about here, that is, I think, entirely appropriate. And most people would be shocked to find that 1 year was the mandatory minimum for having hundreds of images of children as young as 4 years old being raped and abused in any number of ways. And I find it to be really disheartening when you talk to people, and we've had people on this committee as witnesses, such as Liz Brown from Valora Place in London, in St. Thomas, Jennifer Dunn of the London Abused Women's Centre. We had London Police Service Chief Ty Trong. We've had activists and advocates representing women's agencies, child protection agencies. And all of these people every day have to live with witnessing brutality in the world that most of us never have to encounter. They see the pieces that are left behind on the victims that these crimes leave. And I truly, despite our disagreements on this bill, I truly believe that everyone on this committee wants to do right by children in our society and wants to do right by women and all victims of crime. But I feel that where the divergence has happened here is that there's a belief system that is rooted far more in abstract legal theory and less in standing up for victims. And that's what's driving a lot of these very dangerous policies we've seen, not just on bail legislation, but also and especially on things like mandatory minimums, where we get so focused on what law professors and legal scholars are saying, we lose sight of the purpose of the justice system, which is to hold perpetrators accountable for their actions, to deter future perpetrators, and to give some modicum of justice to people who have been victimized by crimes or people whose family members have been victimized by crimes. So when we lose sight of that core objective, which should govern all of the work that we're doing as MPs, but certainly those of us with the great privilege of being on the Justice Committee, of which there are a couple more now that the Liberals have stacked the committee. Welcome to our new colleagues. We have to put justice first, and we have to put victims' rights first. And this idea of just providing a way out for judges who fundamentally reject the idea of mandatory minimums, which parliamentarians have put in place time and time again, the idea of giving judges a button they can press if they feel like it's not fair to put a child pornographer behind bars. That's something that they have. So I want to talk about what this safety valve actually says. Because the safety valve in effect here, when imposing a sentence for an offense that has a minimum punishment of a specified term of imprisonment, a court shall impose a shorter term of imprisonment than the specified term, than the mandatory minimum, if in the circumstances the minimum punishment would amount to cruel and unusual punishment for that offender. To the officials, and again, it will sound like a very broad question, but I'm hoping you'll understand where I'm going, and if you're unclear, I'm happy to clarify. What does "in the circumstances" actually refer to? So when a judge is making this decision of whether a safety valve applies, what information are they permitted to or compelled to bring in as far as that assessment of circumstances?
Thank you for the question. So I think we can expect, because the threshold that was chosen for the safety valve was the constitutional standard of cruel and unusual punishment, I think we can expect courts to rely on the body of jurisprudence that's developed around Section 12 and look at examples of previous MMPs that had been struck down, situations in which those MMPs had been struck down. I think that's there will be a broad body of jurisprudence there for courts to rely on.
But just specifically here, so when it says also whether the minimum punishment would amount to cruel and unusual punishment for that offender. So deciding whether it's cruel and unusual punishment isn't just deciding based on the facts of the crime, it's deciding, as I read that, based on the circumstances of the offender. So what exactly is being drawn into that assessment?
So I think we could expect courts to look at the circumstances of the offense, the degree of responsibility of the offender, the sort of types of factors that courts are used to analyzing when reaching a proportionate sentence.
Would an offender's immigration status be considered?
So I think as part of this analysis, I think they would be looking at all of the circumstances surrounding that particular offender and offense.
So an offender, so a judge who believes that, an offender's immigration status could be jeopardized by upholding the mandatory minimum, that could be factored into cruel and unusual punishment being determined?
Thanks for the question. I'll jump in on that one. So the courts have been pretty clear, and we've talked about it at this committee before, and Supreme Court decision in FAM, the role that collateral consequences can play in sentencing. Sentencing courts are allowed to take into consideration collateral consequences of a sentence, whether that be immigration status, whether that be employment status. But what they cannot do when they take into consideration those consequences is adjust the sentence in a way that would result in the sentence being unfit for that particular offender.
And when determining whether the circumstances are cruel and unusual, there's nothing in Section 718.41, there's nothing in the safety valve that compels judges to look at the effect it will have on victims and their rights, correct?
I think as Ms. Bird has talked about, in assessing whether a particular sentence would be cruel and unusual in the constitutional context, they're going to look at the seriousness of the offense. In looking at the seriousness of the offense, the gravity of the offense, I think that would provide an opportunity for them to consider aspects related to the victim.
I will look up some of the cases you've cited, so if you could please re-add me to the speaking list, Mr. Chair, but I'm finished right now.
Thank you, Mr. Lawton. I'm going to suspend for a few moments. Mr. Brock, I think you have a question?
Yes, there was a question, Mr. Chair. Thank you. There was a question posed to you and the clerk before you suspended approximately 15, 20 minutes ago. A certain number of questions were put to you, and I'm hopeful that you have an answer that you can share with us.
On the basis of the way you put it, I don't have anything to answer because I had a number of questions while we were suspended, but if you have a specific question you want to ask me or Mr. Gill wants to ask me.
Yeah, I'll make it very specific, Chair. Ultimately, if hypothetically we moved to a vote on Roman's amendment, Mr. Baber's amendment, and Mr. Mantle's sub-amendment, that would take us to the rest of clause-by-clause consideration, and ultimately you would be putting a question to this committee, and that question is, shall the bill as amended carry? And I want to know, as members of my party wish to know, whether that issue is debatable.
Or shall the chair report the bill as amended to the House?
As that as well, yes.
Either or.
Yes.
When we get to that point, if somebody asks to make submissions on that, I will allow it.
Thank you.
Yeah, okay.
Okay.
Okay. So we are,
All right, thank you, Chair. On that basis, I understand the conservative position is we move to a vote on Mr. Baber's amendment and Mr. Mantle's sub-amendment at this time.
okay, so we'll have to vote on the sub-amendment first. And then the amendment. Does anybody require the sub-amendment read again or reviewed again? I didn't think so. Read it again. Read it again, okay. All right. Who can do that for us?
Tu Michel ou tu veux que je...
Tu l'as-tu? Si tu l'as, tu peux le
Je
faire.
l'ai envoyé tantôt.
Sinon, je lis tout de suite.
Moi, je suis une seconde.
Okay, I can do it now.
Ouais, vas-y donc, Michel.
Okay. So the English is to replace the text after 1.1 with, in determining the constitutionality of any mandatory minimum penalties, the court shall not consider reasonable hypotheticals. Et en français, même chose, on remplace le texte.
And in French, after 1.1, the text is substituted as follows. In determining the constitutionality of any mandatory minimum penalties, the court shall not consider reasonable hypotheticals. Two scenarios.
Mr. Fortin?
Merci, Monsieur le Président.
Thank you, Chair. I perhaps have a gentleman's agreement to offer to Mr. Baber. Not consider reasonable hypotheticals seems a bit strange in a statute. He means not consider hypothetical scenarios, and I would agree, and I would remove the word reasonable. Otherwise, that the court cannot consider reasonable hypotheticals. It's like saying that it could consider them if they're not reasonable, if they're unreasonable. If that works for him, it works for me.
And if I believe we were getting to the point where we're going to vote on the sub-amendment. Okay. And we are at that point. So, shall the sub-amendment carry? Yes. Mr. Clerk.
Thank you, Mr. Chair. Madame Latanzio. No. Madame Dillon. No. Madame Khalid. No. Madame Gladu.
No.
Mr. Chang.
No.
Madame Akan.
No.
Mr. Brock.
Yes.
Mr. Baber.
Yes.
Mr. Lawton.
Yes.
Mr. Gill.
Yes.
Mr. Fortin.
No.
Okay, defeated.
Okay. Which takes us to the amendment itself, which is CPC 23. Shall CPC 23 carry?
Yes.
Mr. Clerk.
Votes on CPC 23. Madame Latanzio. No. Madame Dillon. No. Madame Khalid. No. Madame Gladu.
No.
Mr. Chang.
Nope.
Madame Akan.
No.
Mr. Brock.
Yes.
Mr. Baber. Yes. Mr. Lawton.
Yes.
Mr. Gill.
Yes.
Mr. Fortin.
No.
Defeated.
Okay. CPC C-23 defeated. So shall Clause 63 as amended carry?
Yes.
Carried.
No.
Okay. Well, go ahead and do a vote.
Okay. On clause 63, Madame Latanzio,
Yes.
Madame Dillon,
Oui.
Madame Khalid, Madame Gladue,
Oui.
Mr. Chang,
Oui.
Madame Akan,
Yes.
Mr. Brock,
No.
Mr. Baber,
No.
Mr. Lawton,
No.
Mr. Gill,
No.
Mr. Fortin. Carried.
Okay. Clause 63 carries. Which takes us to the concluding parts of the process. So we have 1, 2, 3, 4 items before us, just so we're clear. The first one being, shall the short title carry?
Yes.
Carried. Shall the title carry?
Yes.
Carried. Shall the bill as amended carry?
Yes.
Hands up.
Okay, we have a speaking list, starting with Mr. Brock.
Actually, Mr. Caputo.
We have Mr. Baber, Mr. Caputo.
Okay, I've got Baber, then Caputo, but I don't suppose it matters if you guys want to switch. I'll leave it up to you.
Before beauty?
I'm not sure, that doesn't give me any clarity, just to be clear.
Well, touche, Mr. Chair.
Just being honest.
At least you didn't make a hair comment. I've heard enough of those today, Lord knows. Well, it's really great to be back here at the Justice Committee. I wonder if I was missed. And, well, I just heard a no from across the way. Geez, the chair is... The chair... Well, Mr. Fortin says I was missed. The chair is giving me a hard time, and I'm hearing no's
We're
from
glad you're
across
back,
the way.
Mr. Caputo. No, let's get to this important issue.
Let's
shall
get
we?
to that. All right. For the officials, one of the things that I find very interesting in the bill is the importation of cruel and unusual, which is has been defined in the jurisprudence. So one of the things that you said, Ms. Burt, is we can expect that is it a grossly disproportionate threshold? Is that still the threshold for cruel and unusual punishment?
Thank you for the question. Yes, that's what we expect. Courts would follow the threshold of gross disproportionality.
Okay. Now, when you say gross disproportionality and we can expect it, obviously there is some ambiguity whenever something is not defined in the legislation. Is that right?
I think we can expect courts would have, I think as I said earlier, a robust body of case law to rely on, given the threshold that was used. But that's correct. If it's not defined, then it is open to the courts to interpret.
Now, the Supreme Court of Canada is the highest court in the land, as we all know, and they have taken a living tree approach to all sorts of law. In fact, in the decision in, I believe it was Regina and Rodriguez, if memory serves, was 1993, they said there was no constitutional right to die, as in there was no constitutional right to kill oneself through what we called it then, euthanasia. And then Carter came along in 2015. Now, that is a mere 22 years later. That's not very long in the life of the law. And Carter came to a completely different conclusion after just 22 years. There was actually no new statutory law that Carter was based on, as in Carter wasn't interpreting a different provision of the code or of some other federal legislation. Carter was an application, said, I wish to engage in what was rebranded as medical assistance in dying, just as, Rodriguez was seeking to, I believe, strike down the criminal code prohibition on euthanasia. So they were both asking the exact same question, and the court came to very different conclusions only 22 years later when the body of law, that which was being considered, I don't think I'm going out on a limb here saying it was largely the same. The point I am trying to make is this. The gross grossly disproportionate is what the court is saying today. Do you have any idea about what the court will say tomorrow? I get a chuckle, but this is my point.
Yeah, I understand the question. I mean, I think as Ms. Bird has said, there is a fairly robust body of jurisprudence on gross disproportionality. We know it's a high threshold. We know it can't, it is not something that is routinely meant to be found to exist. The courts have talked about it as being something that outrages society's sense of decency, that the punishment in a particular case would be so excessive. But I think you're correct, Mr. Caputo, in the sense that what those concepts mean continue to be informed by judicial interpretation and guided by stare decisis.
Exactly. So you said it much better than I could have said it, and much more eloquently. The point is that Bill C-16, nowhere in Bill C-16 is cruel and unusual punishment defined. Is that correct?
That's correct. In choosing the standard, the government has made a policy decision to import the jurisprudence that Ms. Burt and I have talked about in response to different questions.
It's interesting that you say they've chosen to import the jurisprudence because they haven't chosen to codify the jurisprudence. Isn't that right?
I think in using the standard of cruel and unusual punishment, the intent is that courts would be guided by the jurisprudence that interprets that concept.
I agree with you there that that's what they're saying, but they haven't said, for instance, the bill doesn't say you will be subject to a mandatory minimum penalty unless the penalty would be grossly disproportionate in the circumstances. They didn't say that. Do you get what I'm saying? It is a different. They're using the Section 12 language. They're not using the Section 12 test. Do you get what I mean by that? Am I being clear?
I think so. I mean, I think because the test is different, Mr. Caputo. The point of 718.4 is to provide the courts with a mechanism by which they can depart from the imposition of a mandatory minimum penalty in very circumscribed circumstances in a case where, based on the facts in that particular case, the seriousness of the offense, the degree of responsibility of the offender, other sentencing principles, that the imposition of the MMP in that case would, to use the language of the court, outrage society's sense of decency.
It's a really interesting one. Sorry, I'm going to talk for a second here on outraging society and decency, because in the Senneville case, the outrage of decency from the society in the court's eyes was to impose a 1-year mandatory minimum would outrage the sense of decency in society. So that was the court's decision. See, whereas I think a lot of Canadians here, and I'm not assailing the court's decision, I'm speaking about what I hear from constituents, is that the striking down of that actually outraged a number of Canadians and their standards of decency. So one of the interesting things that we have to look at is what is in Bill C-16, what isn't in Bill C-16. I spent far too long dealing with sexual offenses against children. One of actually the highlights I have coming to Parliament Hill was meeting Justice Moldaver. For those who don't know, was on the Supreme Court of Canada until, I guess, roughly 2020-ish. Maybe 22, something like that. Somebody over here probably knows better. And so I met him, and I met him, and I referenced a decision called Woodward, on internet luring. I could talk about this for hours. You know? Oh, come on. But it would be so insightful, would it not, Ms. Latanzio? Okay. What Woodward said was talked about internet luring and its minimum penalties. Talked about this insidious crime and how the range should probably be 3 to 5 years, and that was when Parliament only had a 10-year maximum. The point I was going to get to that I will make very quickly is this. Nowhere are we dealing with mandatory minimums on sex offenses in C-16, the most insidious types of offenses, like production of child sexual abuse material, internet luring, offenses like that. It should be there. Thank you.
Thank you, Mr. Caputo. I see no more hands.
No more hands.
No more hands? Okay. I see no more hands. Mr. Brock has a hand, though. Okay.
I have another motion for consideration on unanimous consent that I have shared with the parliamentary secretary, and I wish to read it out as follows. Notwithstanding any motion previously adopted by this committee following the completion of clause-by-clause consideration of Bill C-16, the Standing Committee on Justice and Human Rights prioritized its work as follows. Number one, at the May 25th, 2026 meeting, the Minister of Justice and Attorney General appear for no less than 2 hours regarding his mandate, priorities, and estimates as per the motion unanimously agreed to on September 23rd, 2025. Number two, the committee consider Bill C-321, an act to amend the Youth Criminal Justice Act on May 27, 2026, provided that the sponsor of the bill be invited to testify along with any other witnesses deemed relevant by committee members, and that following the testimony, the committee immediately proceed to clause-by-clause consideration of the bill, and the chair only be authorized to adjourn the meeting after clause-by-clause consideration of the bill is completed. Number three, the committee consider Bill C-325, an act to amend the criminal code, increasing parole ineligibility on or before June 17, 2026, provided that the sponsor of the bill be invited to testify along with any other witnesses deemed relevant by committee members, and that following the testimony, the committee immediately proceed to clause-by-clause consideration of the bill, and the chair only be authorized to adjourn the meeting after clause-by-clause consideration of the bill is completed.
Do we have unanimous consent for Mr. Brock to introduce that motion?
Est-ce qu'on peut l'avoir par écrit, Monsieur le Président?
Can we have it in writing, Chair? Can we have that motion in writing in Chair, please?
Est-ce que au moins sur les P9 là?
At least for P9.
Okay, I thought so. Do we have it in writing?
Yes, but it's been modified.
All right, we'll suspend it for a moment to get that in writing.
Louis?
The motion, I understand, has been circulated by email. Mr. Fortin, did you receive a copy?
Oui, Monsieur le Président, j'ai reçu.
Okay.
Yes, Chair, I did receive it.
Are we in a position to vote on the motion then? Yeah.
His microphone isn't on, I'm sorry. Yeah. I have a few proposed amendments. Chair, we had passed my motion in September, last September, and it had been tabled in April. It had been prioritized the study of the system of judge appointment. I think we have a tight schedule. I know there are bills that have to go back to the House, and we have a number of deadlines coming up, but I think we should be able to finish this study, I would suggest, and the motion that we spend 4 meetings on this. So what I propose as an amendment to the motion, and that we introduce a paragraph between 2 and 3 of Mr. Brock's motion, to say that the committee would move on to the study of the judge appointment system for federal appointments after C-321. So 4 meetings, and then make a report to the House as indicated in the motion, and then C-325. That would take us to about June 10th if there are 4 meetings, and it's a study that we've been waiting for many years. I've been calling for it for many years. It had been set as a priority last September. There was consent from the Liberals and the Conservatives. I was quite happy to see that we all agreed on this, and I'm a bit worried that this will just fall by the wayside. It would be regrettable for all Quebecers and for all Canadians who have been waiting for the study for quite a long time. So that's my suggested amendment, Chair.
Ms. Fortin, or Ms. Latanzio?
Yes, okay. Président, donc,
We understand the request as put forward by my colleague, notwithstanding the fact that we agreed to move to the study on the question raised by Mr. Fortin, and given that we have about 7 meetings left, we already have bills, and we will have government legislation that in all likelihood will be studied here at the committee, and so I would be uncomfortable committing to holding 4 meetings where, given that from May 25th, we have only 7 left, and so we won't have time. It's really a question of a lack of time and not of a lack of will. That being said, I'd like to take a few seconds to talk about this with Mr. Fortin, but I would hesitate not because the will doesn't exist to proceed with the study, because all of the members of this committee have already taken a position on this. We do want to go ahead with it, but it's just that we don't have enough time. We only have 7 meetings left. Government legislation is always a priority, as you know, Mr. Fortin. And so for these reasons, Chair, could we just suspend proceedings for a few minutes again?
qu'est-ce que vous voulez faire?
Back to order. We left off discussing Mr. Fortin's amendment to the motion. I don't think anybody wants to speak to that, do they? Mr. Fortin?
Merci, Monsieur le Président.
Thank you, Chair. I just wanted to say that we already had an agreement back in September. I understand that bills might come before the House from the government. I understand that according to the information I have, there are no rules stating that those bills should be prioritized. Nonetheless, I can see why government bills are prioritized here at the bill. But right now we're talking about we're making a decision to for a schedule. We're trying to find time for initiatives we've all agreed on since September. And we can't postpone this, keep thinking about possible bills that might come before the committee. And if other things do come before us in June, the Liberals, my Liberal colleagues, have all the latitude they need. But to say that, well, here's a new bill that's coming down, we have to set aside time for it. But it would be really unfortunate to not proceed with meetings on this study because of something that might happen in a few weeks' time. It would be really unfortunate to postpone this study that we've been waiting for. I understand the Liberals have a majority. I'm not trying to be mean toward our Liberal colleagues, for whom I have great respect, but this is preventing us from making a decision, and I'm just finding that unfortunate. Thank you, Chair.
Thank you, Mr. Fortin. Okay, we'll call the vote now, Mr. Clerk.
Sur l'amendement de M. Fortin.
On Mr. Fortin's amendment and Mr. Brock's motion.
Monsieur Hosfather?
No.
Madame Dillon?
No.
Madame Khalid?
No.
Madame Gladu?
No.
Monsieur Chang?
No.
Monsieur Brock?
Yes.
Monsieur Baber?
Yes.
Mr. Lawton?
Oui.
Mr. Gill?
Yes.
Monsieur Fortin?
Oui.
Defeated.
Amendment defeated. We'll now go to vote on the motion itself, Mr. Clerk.
Sur la motion de Monsieur Brock.
On Mr. Brock's motion, thank you, Chair. Madame Latanzio.
Monsieur Hosfather?
Yes.
Madame Dillon? Madame Khalid? Madame Gladu? Mr. Chang?
Oui.
Mr. Brock?
Yes.
Mr. Baber?
Yes.
Mr. Gill?
Yes.
Sorry, Mr. Lawton?
Also yes.
Monsieur Fortin?
No.
Carried.
Motion carried. Okay, so we'll go back to shall the bill as amended carry? Yes. On division. Okay, shall the chair report the bill as amended to the House? Yes. On division. Shall the committee order reprint of the bill as amended for the use of the House at report stage on division? Nothing else?
Nope, that's it.
Okay, that concludes that. I just want to say thank you. I will say thank you to the members, but I want to say thank you to our witnesses who have been here for days and hours and being incredibly patient and understanding. We're very grateful for that. I want to say thank you to the people sitting beside me on each side, behind me and over to my left, because this has been a long, grueling, unpredictable process, and you've been incredibly patient, and we couldn't have done it without you. Yeah, we couldn't have done it without you, so I just want to say I know we appreciate every one of you, and we're incredibly grateful. And even the people who came to watch, thank you too. Mr. Brock?
Follow up to Mr. Taylor and Ms. Bird. I also echo the chair's comments. Please extend our gratitude to your colleagues who withstood grueling days at this committee as we studied Bill C-16. Their patience was noted and thanked. Thank you.
And lastly, I will thank all the members because it was a long, grueling process, but we got there. So,
With regret, a point of order, a very brief one.
okay.
Thank you.
I know. In light of the motion we just passed, are there any deadlines we need to be made aware of for witnesses, submitting witnesses to the committee?
I believe the next meeting is going to be the minister, which will be Monday the 25th, which then gives us an opportunity to maybe, yeah, because you know what, we'll get an email out to you. How about that? Okay, all right. Okay, thank you, everybody. Meeting adjourned.
Yeah, by the end.